Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we are talking about permissions to reapply. And that's a waiver after you've been deported. So the question is, what are the procedures that are necessary in order to seek permission to reapply? Well, some of it depends on where you are. After the deportation order, it depends whether you are inside the U.S. or outside. But for example, if you're applying for an immigrant visa, based upon spouse or parent or a sibling, whatever it is, and you are not physically in the present in the United States, you should file the permission to reapply with the district office, which has jurisdiction over the place where the deportation or removal proceedings were held. Now, keep in mind, let's say you were deported from Texas, which is the 5th Circuit, and you were going to come back to California, which is the 9th Circuit. If I had my choice, I'd pick the 9th Circuit any day. The laws are more liberal and they're more sympathetic. But you need to file it in Texas, where the deportation order occurred, or wherever it happened to be. You can't forum shop for the best place. Now, if you need to file both the permission to reapply and a waiver, which I have lots of videos on other types of waivers, a criminal waiver, medical waiver, whatever it is, then you need to file both applications at the time you apply for the immigrant visa at the U.S. consulate having jurisdiction over the foreign place of residence. So if you live in the Philippines, both the waiver and the permission to reapply need to be filed in the embassy in Manila. Or if you live in Mexico, then you file it in Ciudad Juarez, and so on. If all you need is the permission to reapply, then of course that goes to the district office where you were deported at USCIS. Okay, now keep in mind that the application procedure for permissions to reapply varies tremendously from consulate to consulate. You can't expect that because you did it one way in Japan that the Philippines will be exactly the same, or that Korea will be similar. You need to make sure that each of the particular consulates is consulted ahead of time, so that you follow the proper procedures and you put everything necessary in the waiver packet itself. Now, you have to prepare a complete and fully documented waiver packet, which that's what is going to decide whether the door's open for you to come in or not. And once the consular post reviews and accepts the waiver packet, then what they will do, since they're not the ones that actually adjudicate it, is they will forward that packet to the USCIS office abroad having jurisdiction over where the consulate post is located. Then if it's denied, of course, you'll have your right to appeal and go forward from there. But while you may think of it as denial, try to make it as strong as you can in the first place to have a better chance of success. Now, if you are still in the United States and you have received a final order of removal, you may apply for the permission to reapply with the district director having jurisdiction over where the removal proceedings were held. And that's if you're in the United States. Now keep in mind that USCIS will not approve the permission to reapply if you need another waiver. So it's only basically you have a deportation order but no other waivers needed. Can you follow, and you're in the U.S., can you follow this particular procedure? And keep in mind that approval of such an application will be conditioned upon your departure if you're ineligible to apply for adjustment in the U.S. Okay, more on the coming videos.